Thanks everyone for sticking around. I'll introduce the panelists briefly here, but the full bios are in this, so I don't need to read the whole thing for you. And then we'll jump into what hopefully will be an interesting conversation about regulatory sandboxing applied to fintech, but also more generally. So directly to my right here, we're joined by Paul Watkins. He's managing partner of Fusion Law, and in previous lives, he has stood up some sandboxes. So we're going to get to talk about those experiences. Ryan Nabil is next to him. Ryan is the Director of Technology Policy and Senior Fellow at the National Taxpayers Union Foundation. He was previously with CEI. And then at the far end, my colleague Brian Knight. Brian has many titles, but he's mostly a Senior Research Fellow at Mercatus.
I just want to say thank you for not saying on the far right.
Well, Brian, since you are my colleague and since I may have said something there inadvertently, you get the first question. Anyone can chime in on any of these, but let's just start with some basics. What is a regulatory sandbox?
So there are many definitions. This one is mine. Regulatory sandbox, a regulatory environment where a regulated product or service can be experimented with in a way that deviates from the standard regulatory treatment. And so that could be, and we see things like, you would normally need a license to offer this, but we will give you the equivalent of a learner's permit so long as you only offer it to a limited number of people or at a limited scale. Or, well, normally we would require this type of certification for the product itself, but we'll waive it. But that's usually paired with some limits in terms of scale and scope and potential customers, as well as information sharing with the regulator. So the idea being that the company gets to try something out that it's not entirely certain it will work, and the regulator gets to observe at a closer level than it might normally how it works and what doesn't, in the hopes that this will better enable the regulator to do its job.
You want to add anything?
I think it is an interesting question. Do I know what the definition of a regulatory sandbox is? I'm afraid I don't. But do I know that there is quite a few different definitions? And that would be right. And the problem sometimes I find is that different jurisdictions would define that very differently. And, for example, for some jurisdictions, regulatory sandboxes are very important for figuring out what rules should be. For example, with the use of artificial intelligence in certain areas of the economy. So their focus would be very much on really figuring out the regulatory framework. For some of the other folks, the EU, for example, that does not seem to be their focus. Their focus seems to be much more like, well, how do we put the company under regulatory supervision and work with them, but there doesn't seem to be the same sort of innovation focus that one finds with many of the US state-level sandboxes. So I think, the way we define it probably is rather critical to the successes of them.
So there's different flavors and you'll get different results. Paul, go ahead.
I think Brian's exactly right. You need real sand, right? You need sand and you need a box for a sandbox. That's my definition. And the sand is exactly what Brian was talking about. This needs to be a good place to experiment. You need to be offering a no action letter, a safe harbor, an interpretation, something that's distinct. And then there need to be parameters. And so some people say, well, we have a sandbox, and the sandbox is you can come in and talk to us. That's not a sandbox. That's just common courtesy. And so I do think the framing is important. I also want to appreciate the chance to be here, and I want to thank the organizers for putting such a beautiful view behind us so that we can see everyone looking at us and imagine that it's they're focused.
So I'm still naive on this. To me, it sounds like, maybe it depends on how you shape it up, but it sounds like you're getting waivers. How is it different just from a bunch of waivers that an agency gives? Because these happen all the time without being called sandboxes. Paul, maybe you can relate this to what you've actually built.
Sure. So what we did in Arizona is we passed a statute and we created a distinct statutory framework that was sort of like an accelerated licensing process for a temporary product, and that was new and distinct. What we did at the federal level, obviously you can't pass a law at the federal level, so we knew that that wouldn't work.
This is at CFPB?
Yeah, at the CFPB. So we looked at existing regulatory authority, and it turns out that the CFPB, the sort of godmothers of the CFPB, designed it with a whole lot of discretion. And so we had enough discretion in that structure that you could offer safe harbors, you could offer no action letters, and in some cases these were built directly into the statutes. In some cases you had to issue some sort of semi rulemaking. So we did testing around AI and particular disclosures and the relationships that banks could have with sort of community credit access folks and those sorts of things.
If I might, Paul raises a really important point, which is that a sandbox has to conform within the existing legal, regulatory, and constitutional structure. You can pass new laws, like Arizona did, like a lot of states did, to say, okay, we're going to create a thing, but the regulator that administers it can only waive that which it has authority over, right? So the regulator can't say, well, no rules apply. And it can only grant as much relief as its jurisdiction covers and as its statutory framework enables.
Does that mean there's going to be? It obviously means there's going to be times when a policymaker might try to push for a sandbox, but just can't build a good, whatever good means, a good sandbox, just limited by statutes.
Absolutely, and I mean, I think what we've seen at the state level is where sandbox efforts tend to flounder or fail is, at least from what I've observed, either the legislature just doesn't want it, they don't understand it, they don't trust it, they don't like it, or there's no sort of champion within the administration to take it over. I mean, if I recall correctly, Paul, the AG in Arizona was the sandbox champion in part because the bank regulator didn't want it.
Yeah, that's exactly right.
Right.
We wrote this up and we thought, aha, we went to the bank regulator and we said, we have this gift. This is groundbreaking, and they've done this in the UK, but nobody's done this in the US, and you get to be the first. And they said, hey, this is not as much of a compliment as you think it is. Why don't you run it? And so we happened to be in charge of enforcing consumer protection, and so we thought, well, this makes sense. If we think that this is not posing a risk to consumers, if we're comfortable with it, we can still bring all the enforcement actions that we want. We didn't give up the ability to bring enforcement actions, but we could also create an environment where somebody was comfortable testing a product. And Brian's exactly right. It is, no matter what the law says or how it's structured, it's entirely administrative discretion as to whether you're going to take the business that you've invested time in and you're going to come to the regulator and say, I'm going to give you more information than I have to, and I'm going to submit to more authority than I have to. And the reason is because I want to be able to reach consumers that I have some question about whether I can reach. There is so much discretion there, and there's really no way to draft around that. If the regulator is not interested in doing that, or the regulator is hostile, or there are some agencies that sort of use information like this just to bring enforcement actions, if that's the ethos or the perception of the agency, then this absolutely will not work.
Paul, you wouldn't know any agencies like that, would you?
I've read about them in the papers. And I actually question whether this structure can work at the federal level. I think this may be something that works exclusively at the state level.
If we though take a sort of a step back, and if you think about regulatory sandboxes as a concept rather than the existing fintech sandboxes as they exist, I think both Brian and Paul mentioned a rather important point in that there needs to be regulatory waivers for participating companies in the sandbox. But then there is a bigger question. Well, what is the point of a regulatory waiver? Now, I think, especially at the state level, there appears to be a growing understanding of sandboxes as a way to provide regulatory relief, but I think there's all sorts of other ways of doing so. And Brian, in one of his very interesting law review articles, I think he points out something called regulatory privilege. So, for example, to the extent that a certain company is in a sandbox, well, its competitors are going to be disadvantaged to the extent that they don't get the same regulatory stamp of approval and whatnot, and also the waiver. So, one kind of also needs to balance that. So I think the point of a regulatory waiver, though, is to entice the companies to join that sandbox and really to see, well, to what extent do the existing legal frameworks work. But I think the broader point, though, is really to try and test out, well, is our existing legal framework well suited to the various products that are being offered, biometric payment system, and to experiment with it at the regulatory level so that we do develop the set of regulations that apply not just to that firm, but applies to all similarly situated firms in that industry. And I think, when talking about sandboxes, sometimes we tend to we focus too much on regulatory waiver as opposed to focusing on the broader question of what that sandbox then is supposed to do.
So this is for calling my law review article interesting. I appreciate it. I'll get to you later. But you raised the absolute correct point, right? That if a sandbox is just, hey, here's how the regulator rewards his friends and punishes his enemies, and you get the golden ticket and you don't, that's worse than the status quo. What you want is or one of the big important parts of this is that hopefully it provides concrete information that regulators and policymakers can use to say, in effect, this company came in and we waived this rule and the sky didn't fall. So you know what? We can get rid of the rule. Or we waived this rule and the sky did fall, and so, okay, this rule, don't touch this rule. Or, wow, we thought this is how you had to solve a problem. These guys came in and said, no, we think we have a different way to solve the problem. We'll let them try it out, and lo and behold, it worked. So now we as regulators know that and can get comfortable with that. And one important thing that when they ask me, what should our regulatory sandbox have, I always say, you need reporting up to the legislature and you need reporting out to the public. Up to the legislature so that legislators can see, oh, okay, well look, I'm seeing that this worked out, and so maybe you, the regulator, feel like you're hidebound to this rule, but if I can get this data and we as legislators can look at it, maybe we can change the law and resolve that issue. And out to the public, one, so that voters can understand what's going on and make good choices, because that's really important, and two, so that to the extent that novel questions of law as applied to fact come out, other market participants can leverage that information. Because the risk is, if you have this sort of closed loop where one market participant is talking to the regulator and they're kind of going back and forth on here's how we think this works, and okay, we think that's okay, blah, blah, blah. The risk is that the regulator becomes a de facto consultant or a de facto law firm on part of the market participant who's in the sandbox. But if you can then socialize that information out to everyone else, that helps address part of that regulatory privilege problem.
Yeah, just a quick point to that. So, I think, so it is important that whatever is happening within the sandbox, what are really the regulatory lessons and such, to the extent they can be revealed to the public and to other companies, I think that is good. Interestingly, I was checking the Norwegian AI sandbox. They're one of the only sandboxes that actually, for every company that sort of has participated in their sandbox, they'd give a report. But with regard to going back to the question of regulatory waiver, I think what's also interesting insofar as we are thinking, well, sort of we've got existing rules, and to what extent should we waive those rules versus not? I think it's also interesting to think about what is the stage of maturity of a given sector or a given industry in which that sandbox is being introduced? Because I think that would very much help determine the ideal approach. So for example, if you're doing something like, say, insurance, I think that would be a sector that is heavily regulated, but the rules are already there. And then one is thinking, well, right, well, that rule can be rather cumbersome, and let's see if we can do without it. As opposed to in a sandbox like actually, Brazil has announced a new AI sandbox. And their sandbox, I think, is interesting because one of the things they're trying to do is the Brazilian government is trying to figure out to what extent Brazil should mandate in their law explainability for algorithms. So we've got AI algorithms, but can we really explain it? That's a huge issue in that sphere. And then the point of the sandbox really is to figure out, well, to what extent should we have explainability, because they're trying to figure it out. Because sandbox is being introduced to a sector that is not very, it is rather emerging. So I think depending on the nature of the industry, even within the fintech world, I think, I think then that would very much affect, well, how would we design that sandbox program?
If I can just push back a little bit on the idea that there's, about the market advantage of being in this sandbox, I actually think the biggest problem with running a sandbox is the opposite, that there are too many restraints. There have been examples. One of the most successful sandboxes in the world, of course, is the UK sandbox out of the Financial Conduct Authority. And one of the reasons why that works well is, for one, it's a pretty strict regulator. So people are very worried about what they think. They have a lot of discretion, and they control a lot of the licenses. So unlike here, where it's divided state and federal, and then the federal split up in a bunch of places, you can just go to the FCA, and that's the opinion that you need for launching your product. But they have specific time periods, and there have been examples of companies who have been locked into this sandbox and have had a hard time pivoting because they had to get permission from the regulators to change whatever their initial approval was. Meanwhile, folks on the outside are just pivoting away, hoping that nobody brings an enforcement action against them. And if they're right, if there is no enforcement action brought, they're in a better spot. In the US, there's been a similar challenge, but a little bit different dynamic. There was a company that was in a CFPB program, and they were using AI and machine learning and underwriting. And it just became politically expedient to attack this company. So people on the Hill just started smacking them for reasons that didn't have much to do with actual data. And the company at the time was trying to get ready for an IPO and so forth. And they were singled out simply because they were part of a program run by the opposition party, and there was a political incentive to hit anything that the opposition party was doing. So I think for a federal, if I were talking to a young company that was thinking about participating in a federal program like that, that's going to be very high profile, I don't know. I'd say the risk of having your company attacked for not good reasons is pretty high. Maybe you should try to get some sort of generic statement or interpretation or something that applies broadly but doesn't single out your company. Maybe that'll be more useful than being in a sandbox.
I think it is also interesting perhaps to analyze why in certain other jurisdictions, like the UK, it would be, to say that one has participated in the Financial Conduct Authority sandbox, it would be very much of a stamp of approval to a certain extent that it wouldn't be in the US. Now, why is that the case? Well, I think then we would have to think about really the way that the financial regulatory architecture is designed. So in the UK, it's very much it is much less complex. There is not really an overlapping dual state jurisdiction, and also even at the national level, there isn't as many regulators. So when the FCA does have a sandbox, that is the UK fintech sandbox. As opposed to in the US, well, there's not really despite CFPB's best efforts, and thanks to you, but there isn't as many like federal sandboxes.
It's all undone now. Anyway,
yeah, exactly.
Very clearly said we're not doing any of that stuff anymore. Right. when the new folks come in.
And state sandboxes then have two problems. Well, firstly, many state sandboxes actually they do have a sandbox on paper, but people aren't really applying. It's not really as attractive. There's a PR side to it. But then there is also, as Brian and Paul were discussing earlier, as a state regulator, you can only waive so many regulations. So, to a certain extent, and I think Paul is right on this, that how much regulatory waiver are you getting versus how much criticism might you potentially get for having participated in that sandbox? I think that balance does not look terribly favorable. So if I were an entrepreneur, I'd much rather participate in the UK sandbox than I'd do in the US one.
So, Patrick, I apologize because I know you have a ton of questions.
No, this is great. Keep
okay.
going.
So the interesting law review article that I co-wrote with a former colleague that Ryan mentioned is called the Sandbox Paradox. And the paradox, as we saw it, is that for a sandbox to be useful, it has to be valuable to the market participant, or else they just won't use it. But if it's useful to the market participant, it risks granting a competitive advantage to market participants outside of the sandbox. But the other, the side of it that we didn't talk about, which is what we're describing here, is like, one, sandboxes are not panaceas, they're not cure-alls, they're not like the one, if you just have this, your economy is going to shoot up and innovation is going to be great. They're a tool in a box that has to work with other tools. And they are very much products and beholden to the political economy of the jurisdiction they operate in, which is, fancy Mercatus speak for saying, if you're in a world where your government is going to target companies for political purposes, the sandbox is not going to save them. Or if you're in a world where the regulator is, where you need regulatory permission to breathe, sandbox might help a little bit, maybe at the margins, but maybe not. The other risk, another risk in that scenario is that regulators get in their mindset, that like the good companies are the ones who go through the sandbox. And if you don't voluntarily go through the sandbox, well, are you trying to hide something? And so if there is a problem or if there is an issue, as can inevitably occur, the companies that have gone through the sandbox are maybe treated a little bit better than the ones that are not, or it's viewed as sort of, it raises enhanced skepticism. And so when we're talking about the future of regulatory sandboxes, it is not a separate conversation from the future of our regulatory system writ large, or frankly from a separate conversation from the health of our democracy, but it flows from that.
I think Brian's certainly right. One interesting point, if you were to, there's a lot of sandboxes in the world, but around the world, but which ones are successful? Mm-hmm. Well, the one in the UK, yes, but also the ones in Hong Kong, ones in Singapore, ones in South Korea, Australia. One interesting thing that does happen with these sandboxes, one challenge I think with the US financial regulatory architecture in this sense is there are too many actors that want too many different things. So there isn't really a uniform approach. Whereas, so for example, the UK's AI sandbox, what it's supposed to do, it's part of a fairly unified approach. Sandbox is very much part of other policies in trying to understand and shape other policies in a way that the UK's fintech sandbox was also the case for the fintech sandbox. So I think it is important to consider too, in terms of where does the sandbox fit into the broader regulatory architecture and what are the broader regulatory objectives, and sandbox can really help as a tool to those objectives rather than just creating a sandbox and then figuring out what to do with it.
Yeah, I think you've seen some anecdotal evidence of that. The UK and the MAS in Singapore, they've been able to adapt to digital assets, for example, better than our regulators are here. I mean, we've had digital assets in this country for a decade, and you still have agency heads coming into Congress, and they're asked, is this a security, is that a security? And they can't answer the question. And they periodically sue, and maybe a court will tell them what the answer is eventually. But there are other agencies that have been moving forward and I think have learned from the products that they've seen, and maybe they just have more of a competitive incentive to get to an answer, and they've been able to develop a structure.
Another naive question. When you say, Ryan, you in particular, you've used the words successful sandbox a few times, but what does it actually mean to be successful? You have a lot of users?
Well, I think that's a very good question. What is a successful sandbox? I mean, in a way that is very hard to define, because the way I would have defined it would be a sandbox that achieves its policy goals, which could be all sorts of different things. Different sandboxes would have different goals. In my understanding of sandboxes, I would say a sandbox that plays the role of designing a more pro-market and more competitive digital economy or sector of the economy and promotes innovation in that sector. What I had meant by that statement earlier, I think successful would not have been the right choice of word. I think I should have perhaps used the word popular, in the sense that that is the sandbox that have had the highest list of participants, because that is something you can measure, as opposed to trying to measure to what extent a sandbox has been successful.
we had Sandbox and then broader guidance programs. And so our goal of the CFPB for Sandbox was we learn something and then we translate that into a broad statement that we can provide to the industry to provide clarity so that everybody can kind of move forward and understand how we think about this issue.
Yeah, Paul, you mentioned earlier in Arizona the bank regulator, I don't remember the specific name, but they opposed doing the Sandbox and just handed it over to the AG, right?
Yeah, which was, it was fair. We wrote it, so, and it was new. I can see why they did that.
In general, if we could list those who oppose Sandboxes, is it just mostly going to be the existing regulators, or are there other factions in this battle, so to speak?
Oh boy, you're really going to get me in trouble with that question. Let me talk about how hard it was to find supporters and information when we were doing this back in 2016, or I think it was 2016. And I want to thank Brian Knight because he's handing out cash on this panel for one thing. But he had written a paper on fintech and federalism. So we were able to call the FCA and we could talk to them. We couldn't get anybody to talk to us. They were just like, Arizona, what's Arizona? I don't even know where that is, and I don't care. And Brian talked to us, the UK talked to us, some other international regulators talked to us, and we were able to put together a law based on that. But that was simply just Googling the terms, finding Brian's law review article, and then saying, this is somebody we can talk to write a law, and that was very helpful. So those were sort of the supporters. I remember the first time I testified, I thought, we've done something remarkable. We have reached an ecumenical state in Arizona, because I looked at everybody who had signed in on the other side, and it was every single faith-based group that I had ever heard of. So all the religions were united against our bill, thinking that this was a backdoor way to introduce payday lending into Arizona, because I think when people think about financial regulation, they essentially have two categories. They have, this is something that big banks want, and this is something that payday lenders want. And it didn't look like a big bank thing because it was more competition, and so they assumed this is a payday thing, and it wasn't, and we never had anything to do with payday, which is still illegal, and our law said it was going to be illegal. So, so I think there are people who maybe didn't understand the product and were opposed to what they thought we were doing. And then there are a number of people who exploit that misunderstanding. And I don't think I'll single those out by name, probably, but they exist.
There is one, perhaps, anecdotal evidence which must be treated with skepticism that I would add to your insightful analysis. So, when I would see people that are interested in sandboxes or designing them, do I see certain trends in what type of people they are? Now, I think in Singapore and Hong Kong and in the UK and such, I think the type of people that you would see would be like the legal innovator types. So they think that, well, the legal system must innovate, and we must think about the strategies for regulatory strategies for doing that. So I think that would be like one sociological type. In the US, though, I think it's a little more interesting, perhaps. Firstly, it's not an idea I hear from the federal type folks, federal policymaking types. Oh, let's create a sandbox, and how would that look like? It is something I would hear much more at the state level, like when you're at the State Policy Network conference, or when you're at ALEC. That is often I would be asked in, say, a happy hour. Well, what would that look like and such? But then I think there is a partisan issue, to the extent that the people that would be interested in a sandbox, in the US, it does seem to have a certain reputation that it's a partisan issue. It isn't that way in all jurisdictions. But what I found interesting, well, sure, I think right now it has a reputation that, well, sandboxes are something that only conservatives would support. But I think there are all sorts of other ways of gaining bipartisan support. I can think of two such ways. The last time I was hanging out in a wireless, many of the progressive students, they had supported, in conversations, they had supported the idea of a legal sandbox, which I think is rather interesting, because whereas fintech sandboxes in the US have not been very successful, the legal sandbox, the one in Utah in particular, have been very successful.
Can you tell us about that?
Sure. So essentially, well, I haven't studied that in a while, But essentially, so there is a barrier to it. So if you're a non-lawyer or if you're a non-law firm, you cannot provide legal services. And that is regulated at the level of states, not by the federal government. So what the Utah Supreme Court had done is by virtue of a standing order, they had created a sandbox in which non-law firms, especially ones with a technological background, could come in and they could offer products in 4 predefined areas of law. So it can't be legal representation. A robot is not going to represent you in a court. It happens more in the sense of, well, you can offer automated services in the writing of contracts and things of that sort. So they are trying to introduce legal innovation in that sphere. And that has been very successful to the extent that there has been a lot of participants and there has been also interesting products that have come out of that system. So I think legal sandboxes would be one area where I think there could be bipartisan support. Many Democrats are indeed passionate about access to legal justice and such. That would be one area. But the other area, I think, would be something like artificial intelligence. And in many ways, I think when you're creating an AI sandbox, that is something for which both the Democrats and the Republicans would have support for. But when you're creating an AI sandbox, it really has to be sectoral AI sandboxes. But one interesting possibility is to create a federal AI sandbox for, say, financial technology or the financial services. But that would be an area, if pitched as an AI sandbox, I think that is one area where I think one is supposed to get at least equal amount of support or opposition from both parties. There doesn't appear to be as much of a clear partisan divide.
One small note is, one thing that's interesting about, say, the FCA in the UK is it has an explicit competition mandate, whereas most domestic financial regulators do not, or to the extent they do, they tend to ignore it.
CFPB does.
Yeah, but they trot out like, oh, don't worry, we have a competition mandate, and it's like, what are you doing to increase competition? Like the SEC has capital formation as one of its tripartite mandates, but balancing 3 different mandates is hard. And so one of the reasons why I think the FCA was so gung-ho is that they had a competition mandate, and that the British government was very much in the, we wish to be the financial center of the EU, and then after Brexit, we wish to be a financial center that can compete with the EU. Mm-hmm. So go. And if there's some trouble along the way, it's okay. Whereas the incentive structure for certainly federal financial regulators in the United States, and probably at the state level too, is very much biased against risking innovation, because if grandma loses all of her money, you get yelled at. If economic growth goes up a little bit in some kind of vaguely undifferentiated way that it'll be hard for you to claim credit for, nobody cares. And so that is a political, cultural problem that needs to be addressed, that then flows down into sandboxes and everything else. Yeah.
I do think there's a meaningful difference, though, in the federal approach and the state approach. Mm-hmm. If you take the deepest blue, the 2 deepest blue states, New York and California, are the 2 most significant economic centers. Their approach to innovation and this issue is much different than what you would see from Sherrod Brown or Maxine Waters in Washington, D.C. So you've had banking commissioners in California issue, they didn't call it a sandbox, but it was essentially, here is how you can operate your earned wage access product for some period of time while you provide us information. Very close to a sandbox. You've had New York, when they first instituted their BIT license and everybody left New York and said, this is too onerous, we're not going to deal with it. They brought in new personnel and they changed and restored their place in that ecosystem. So I think there are incentives at the state level that cross over party lines and lead to really constructive behavior. It's just that I don't think those incentives exist at the federal level, where the political benefits of attacking your opponent dramatically outweigh building anything with your opponent.
I think that there's another interesting component to Brian's point, which perhaps you might not have thought about.
Perhaps not.
And that would be, so when you think about the UK and such, right? So
It's a nice place.
No, well, the FCA in particular. So I mean, they do have very much a competition mandate and such. But then if you think about, I think there's a cultural, there are cultural forces at play here as well. Culture in the context of financial and legal services. If you think about the jurisdictions that have put a lot of priority on creating sandboxes, I mean, the three top ones that would come to mind would be the UK, Singapore, and Hong Kong. Now, what do they have in common? They're all three jurisdictions that very much wants to compete. The UK in Asia and Hong Kong and Singapore are competing with each other in being the leading financial innovation center in the Asia Pacific. So I think what you would find though is in the broader culture of financial regulation, I think there is a certain emphasis that is placed on innovation and global competition, which then is reflected in the bylaws of organization and also also sometimes in statutes, as is the case for the FCA. So I think there's a cultural aspect we're not considering as well.
Well, no, I mean, I completely agree, and I actually did think about it. But that would also line up with what Paul said, right? Because the two examples he gave, California, Silicon Valley is a big driver of the California economy. And a lot of these fintech, fintech's half tech, right? And New York is, of course, a major financial center, but is also, this may be optimistic on my part, but like its ability to be the locked-in financial center is weakening over time. So they might actually have to compete more to keep business. And so, but also, finance has political power within the state of New York. It does not have in Ohio, and it does not have in other, in other jurisdictions. So yeah, I mean, it doesn't surprise me that the more innovation-friendly progressive states also are the ones who have the political economy that would drive them to support that type of thing, and that's great. Like by all means, and states do compete with each other, right? Like if Arizona wasn't and Utah weren't making the play to be like, hey, we want to be actually really competition and innovation friendly, and we're not that far from California. Mm-hmm. How does California react? I don't, you can't guarantee they'd react the same way.
Right. Yeah, that was our initial impetus. There was an event in Arizona, which was like, I think what venture capitalists do for pro bono, which is they go into the rest of the country and talk about how much smarter everybody is in Silicon Valley than wherever they happen to be talking. And so we went to one of these events and thought, well, we got to build something distinct because we were just told there's no reason to talk to anybody that's not 15 minutes from Sand Hill. And so that was part of our motivation.
That was during the zero interest rate times. Okay.
It's yeah, things have maybe changed.
I'm going to open it up to questions in just a minute here. But before I do, I did want to see, Paul, if there were any other lessons that you wanted to convey from your time standing up some of these sandboxes.
I guess I'll say two things. So I think it was Brian's point about the overall regulatory framework. You're helping somebody get to market, and that's an important hurdle to help somebody cross. But potentially a bigger problem is not getting to market, but it's scaling your product. And so a sandbox, if you really want to generate economic activity, I think needs to be combined with reciprocity, not just in the sandbox, but for the other state licenses. So somebody can scale within a state and then immediately access a much larger market. I think that sort of structure would be really powerful. And then just to Brian's point about New York's incentives, at the federal level, Washington, D.C. is such an incumbent-dominated town, I think because the startup costs for engaging in public policy are so incredibly high that you have to have an existing business to really be able to play here. And so when you have the incumbents and then sort of people who are thinking that they're defending consumers. When those two groups align, and they've aligned against fintech and crypto and other examples, that's incredibly difficult to break at the federal level. But that combination doesn't seem to be as powerful at the state level, even in New York, which you would think would be dominated by incumbent financial firms. For whatever reason, those firms seem to have more influence here than they have with New York policy around innovation, and I haven't quite figured out why that is.
If I can add quickly to Paul's point, I think Paul does mention something rather interesting, especially sort of at the state level, something called reciprocal sandboxes. I think that is perhaps a rather underexplored area in the context of when we talk about designing sandboxes and whatnot. And I think an idea like that can sort of take all sorts of shape. So one such example would be that think about if you're, well, not all state sandboxes are doing that great, but if you're a particularly innovation-friendly state and you want that state to be like the regional hub of that region, really, there are rather interesting things you can do. So, for example, one thing you can do is you can combine the regulatory sandbox with something called an innovation hub. What do I mean by that? So, suppose you are Texas or Arizona, and you're trying to, get sort of different type of businesses. Suppose you want to have a lead in a particular area of fintech or AI. You can design a thematic sandbox that would invite companies that really work on that. So, for example, Thailand did it with QR codes at a time when QR code wasn't really a thing. So that was, that was a very thematic sandbox. They wanted to promote innovation regarding that. So there are designs you could do. You can design a thematic sandbox and such. One of the other things that I see many sandboxes make the mistake of is they have very restrictive entry criteria. So you can, ideally, it should be open to businesses from all over the US, but I think also an interesting idea is why not make it open to businesses from around the world? Because I think what then you would do, I think many companies overseas would want to invest in such, but sort of like Arizona, that part of the US is often not terribly well known. So if there's also an innovation hub that kind of works like a foreign investment office saying, okay, well, here's our, Texas is a huge economy, but people don't know that often. If one had more information about that sort of stuff to go with the sandbox, go with the regulatory sandbox, that also helps people knowing how to apply to that sandbox and things of that sort. Then one can have reciprocal sandbox arrangements with sandboxes in other countries. The FCA, for example. How that works as a matter of constitutional law, I think that goes beyond my knowledge. I'm looking at you, Peter. Perhaps you'd be able to answer that. But I think especially if you're looking at reciprocal sandboxes, I think there's all sorts of interesting ideas that could be designed that would help companies from.
At least within the states.
Sure.
Brian, do you want to chime in on this? Or?
No, I'd like to leave some time for questions.
All right, let's open it up for any questions.
I'm going to look real stupid if no one asks a question, so someone ask a question.
We did sign one of those with Taiwan and I think a couple other countries, and we're
Arizona or
we're aware of the provision that says you're not supposed to sign contracts with foreign governments. So this is a regulator, so it's different. I don't know. Nobody sued us.
Yes, sir.
Thank you. My name is Yaya Fanas. This is for Brian. Initially, you said you want your program or whatever project to have the regulators be into it, to know about it. So in other words, you're teaching them, right?
Yes.
That's what needs to be done, because most of these regulators, they're incompetent, so you have to teach them and coach them. I know I worked for the state government of California for 30 years, California Public Utilities Commission, and I knew that most of the staff are not competent to meet with the regulators that they are doing. It's a knowledge mismatch.
They're asked to do something really hard, like something like AI or digital assets that comes in that's new, and you don't know what the consequences are, and you're supposed to solve this, and if you make a mistake, you'll be blamed for it. That's hard.
A little gauche to ask one more question since I've been talking all day, but I'm curious, what federal agency, if you could just parachute a regulatory sandbox project into any federal agency that hasn't tried it yet, which one do you think would benefit the most from this approach to their current approach to rulemaking or regulation?
I don't think it would work at any federal agency. I think what you could do is have a safe harbor like Hester Peirce. So I'd probably say the SEC because there's a lot of innovation going on in that space, and they haven't really moved forward in the last decade on it. So I think you could have sort of a safe harbor with certain characteristics where you can avail yourself of the safe harbor like Hester Peirce has proposed. I think you could have guidance. But I think if a company singles themselves out at the federal level and says, we're distinct and we got this waiver, that you're going to be attacked, especially if you're successful. You'll be attacked by your incumbents, by your challengers. They can easily find support on whoever the opposition party is. And I think that reduces the utility of a sandbox.
There's perhaps another component to that. So, we can think about, well, what do other major jurisdictions do? And I think one major trend that you would see would be that the data protection authorities of different countries launching their own sandboxes because they're trying to figure out, well, how does a new product with implications for privacy, for example, interact with existing bodies of law and such. There is not really a data protection authority in the US, but oh dear, one thinks of the FTC. But the problem with many of those agencies, though, is that they tend to get very politicized. So, the quickest way to get fired in the UK, at least back in the days, now it's changing a bit, as a bureaucrat, is to go out and say, oh, I'm bureaucrat X and I support party Y. Bureaucrats are supposed to be non-partisan, and they're not, in their official capacity, they're not supposed to have positions. So I think that would be a structural issue that I do see with some of the regulators having their own sandboxes, in that, in a theoretical world, could I see the FTC having a sandbox in trying to understand, well, what sort of privacy rules should we have, for example? You can also think about that in the context of financial privacy under other regulators and whatnot. But the problem I find is that, there isn't the same sort of fact-finding, objective, neutral approach that would characterize other regulators that normally create such sandboxes.
So Paul kind of took my answer, both the despair and then also maybe the SEC. But I guess if I can't pick that, the NCUA comes to mind because the NCUA very rarely comes to mind. And I'm not a credit union expert, so I could be totally wrong about this. But what you want is an agency that has, as much as possible, total jurisdiction over its industry. Because you'll get only as much regulatory relief as your strictest regulator will give you. You want one that, at least to start off with, that isn't in an area that's super hot and contentious, and I think credit unions generally fit that mold, right? And so that might be an area where you could try it. But I do agree with Paul that the political, both the statutory, assignments of authority, but also just the political reality, makes the federal government a hard road to hoe for this type of thing for the foreseeable future.
It seems to me that there's some sandbox lights, so to speak, that we've already seen from some agencies, like guidance that DOT put out about autonomous vehicles. Kind of a sandbox, right? It's saying, here's what we're thinking about, how we're going to interpret the old regulations or the new regulations that we might be doing, so you can go design your cars accordingly.
So I hate to say this at towards the end of the conference, that sandboxes aren't actually new, because if you think about something like drug trials, yeah, go try this drug on a limited number of people and let us know if it works, and then we can decide whether to move forward. Or the SEC's no action letter regime, where it's like, okay, you come to us, you tell us what you're going to do, we're going to look at it, we're going to say, okay, based upon what you've said, we would not recommend that we come after you, and technically this letter only applies to you. And yet everybody says, oh, well, we're operating in accordance with this. We're Vanguard, but we're operating like the State Street letter. And the SEC can't then or at least shouldn't, be able to go like, oh, well, no. We just broke the law for those guys. We have to break the law. Because no action letter is not supposed to be like, the law doesn't apply to you. It's, we believe the law applies in such a way that we would not think enforcement would be appropriate. So yeah, I mean, in some ways, this isn't new. There are some unique wrinkles, but also, marketing matters, right? Like the FCA made a lot of hay over its sandbox because they want to draw industry to the UK.
Yeah.
Actually, so in terms of the light sandboxes, I mean, our first question when you had asked, well, what is a sandbox? I think there is perhaps a definitional criterion that many of those programs would not meet, and that is, well, a sandbox like that really has to be time limited. So you're getting that no action letter or regulatory relief for about a period of, say, 1 month to 1 year to 2 years, or whatever the regulators might decide, even on a case-by-case basis. But the issue that I think could be the case with many of those type of programs is that, well, does it really have an end, or is it that one gets no action letters then for 3 years, which then can be continued and such, so forth.
Yeah, I can see that creating a lot of uncertainty and that deterring potential big investments.
Or regulatory privilege.
Or the other way around, yeah. Any other questions?
Please join me in thanking Mercatus.
Well done.